I'm Dean Gillian Lester. Many of the faces out there are faces people I've met, but this is a nice opportunity on an ongoing basis as we kick off our first Lawyers Community and Impact for faculty to get to know students outside the classroom setting. We inaugurated this series of events. It's often panels, but it's exclusively panels. Sometimes it's individual speakers, and sometimes we've even done service activities together as part of Lawyers Community and Impact. We inaugurated it, this is our third year, a couple of years ago with the idea that it would be a way for us to take the things we learn every day in the classroom and connect them to what's going on in the world around us. There are so many ways that we'll be trained well when leaving Columbia Law School to be practicing lawyers in public and private settings, sometimes in law firms, sometimes in companies, sometimes in the government. But no matter what we end up doing with this training, we'll be particularly acute observers of events in society with a very new lens after studying law than before we came to law school. We better understand how the Constitution works. We better understand how the different parts of government work. We better understand how regulation works. Just picking up the New York Times or the Wall Street Journal becomes a very different experience after studying law. And so the purpose of the Lawyers Community and Impact series is to help you start to make those connections while you're here at Columbia, and hopefully to stimulate interesting conversations outside of class, to help you get to know your professors a little better, and I'm just going to use a big word, but the thrilling work they do as scholars. Help you understand their great minds and their great work and the ways in which they have a deep understanding of ideas of society and how the law applies to those things. And to make it just more fun, just to make it more fun to be here and to be part of an engaged, lively, intellectual community in which what you're learning is relevant to the world around you and you understand the ways that that's true. So with that, I'm actually not giving the introductions of the panelists. Professor Johnson will be giving the introductions of the panelists. But with that, I just want to say a hearty welcome, and I look forward to seeing you not just today, but at many more Lawyers Community and Impact events during the course of this year and beyond.
So thank you, Dean Lester, for your leadership in starting this series, which I also give credit to Jamal Greene, who was one of the first people who thought about doing something along these lines. And then, of course, to Professor Bert Huang, our Vice Dean for Intellectual Life, and Yadira Ramos-Herbert, and all the wonderful people in Student Services for organizing. It's always great to see such a good turnout at these events. And it's not only because we forbid you from having any other event at the same time. We think it's because we try to organize things that are topical, interesting, and that allow you to connect with faculty, as Dean Lester said. So I'm Olatunde Johnson. I'm a professor here at Columbia Law School. And so this panel, as you know, is about the future of the Supreme Court. We'll also touch a bit on the confirmation process, but it's about the future of the Supreme Court in the wake of the nomination of Brett Kavanaugh. I'm going to very quickly introduce the panelists and get into questions really quickly, as we never seem to have enough time for Q&A or all the discussion that we want. So we have Jamal Greene, who is the Dwight Professor of Law here at Columbia, and he's a specialist in the Supreme Court and constitutional law and legal theory. Kellen Funk, who is the newest addition to our faculty. He's a legal historian. He just started in July and has an interest in courts and constitutional history, among other areas, teaching an exciting seminar this semester on bail reform. And then we have Jameel Jaffer, who is the inaugural director of the Knight First Amendment Institute at Columbia that I encourage you all to learn more about. It was started in 2016 with the mission of safeguarding free expression in the digital age. And prior to that, he was deputy legal director at the ACLU, where he worked on free speech, privacy, national security issues, among many others. And He has written a lot of briefs to the Supreme Court and even argued before the Supreme Court. Professor Metzger, who's the Stanley H. Fold Professor of Law at Columbia, and she's an expert in constitutional law and administrative law. So I wanted to start this by talking about the confirmation process. So first I wanted to ask Professor Greene, you know, I was looking at Twitter, or someone tweeted me something, and they said, "Is that Professor Greene sitting there at the confirmation hearings?" And so we just, you know, kind of blew it up, and we said, "Oh yeah, it is. That's definitely Jamal." So you were actually there, and so I just wanted to invite you to talk just a little bit about what you saw. And as a way of having us, you know, understand what's at stake here and what's going on in the confirmation process more broadly.
Sure. And thank you. Let me first say a word of apology that I actually have to leave a little bit early to catch a flight. This dismays me more than it should dismay you, because I want to hear the rest of the talk as well. But so I apologize for that. As Professor Johnson said, I was assisting Senator Kamala Harris at the confirmation hearing. So that's just kind of by way of full disclosure. Anything I say here is just my view, not her view. The hearings generally, I think, you know, the big take home for me, I think, is you have to think about the hearing not in terms of whether anyone of relevance, that being a senator, was persuaded on the merits. I think Brett Kavanaugh's confirmation is extremely likely. It has been extremely likely from the start, and none of that, I think, especially changed during the confirmation hearing. One never knows. There are a couple of potential votes in play both ways, but again, it's extremely likely that he's confirmed. And so, if you think about what counts as a win or a loss, or what counts as success for either side in the confirmation hearing, for the Republican side, it was simply a matter of making sure he didn't make any mistakes. And on the Democratic side, I think it's a matter of trying to create enough of a cloud around his nomination and about his views to be able to use it as an issue in the midterm elections, either to attack Republicans or to defend Democrats who are in swing states and might have to defend a vote against him. By those measures, I think both sides were reasonably successful. I do think that there was one, I think, somewhat significant strategic error made in the course of the confirmation process, and I think that was made by the Republicans. There were a number of process issues in the hearing. It would take way too long to get into the specifics of all of them, but there are about 4 or 5 distinct issues relating to the withholding or concealment of documents connected to Brett Kavanaugh's time in the White House in particular. And there were a number of documents that the committee did in fact receive, and here's where I think the error comes in, that they did in fact receive, but that were labeled as what's known as committee confidential, which means they only go to the committee and they're not allowed to be used openly in the hearing or provided to the public. It turns out that these documents, so usually that designation is used for documents that have private information, social security numbers, or a health condition, or something that really does need to be kept private. The Republicans decided on a unilateral basis to use that designation for certain politically sensitive documents, not so politically sensitive that they would really change the outcome here. And so that's where the error comes in. So the Democrats are able to say, look, they're hiding all these documents from the American people. You know, my question is going to be about, you know, the smoking gun that's in these documents, but that they don't want to show you. When in fact the documents are not all that smoking, right? So that ends up giving an issue to the Democrats, and they kind of ran with that. So that became kind of the story of the first day of the hearings in a way that was probably not that helpful to Kavanaugh. But again, this is a kind of a fait accompli for the most part. And so this is really just about the politics surrounding the vote rather than whether he gets confirmed or not.
So thank you for those observations. I was going to turn to Professor Metzger, because you also watched a lot of the hearing. Can you talk a little bit about what you saw and what you expect to come out of the process?
Is that on? Yeah.
I think
Okay.
so.
Well, so one thing I saw was Jamal, and sent him an email or a text saying, "Hey, is that you?" I had a similar. I mean, I completely agree with what Jamal said. I don't. These hearings were not likely to change results. I don't think anything that came out necessarily changed the results. My own sense was that although Kavanaugh did a good job, I think, in not not giving Democrats any significant ground and not alienating any Republican support. As we were, this came up when we were in a discussion we were having on Monday. He looked awfully guarded. He is actually a very sort of smart and in some ways personable guy, and he just the whole background of trying to shield documents, his involvement. I don't think he was portrayed in a particularly appealing light as he otherwise could have been without that. I do think that it's interesting to think about what the purpose of these hearings are. Fundamentally, I think it's important that before somebody goes on the Supreme Court, there be a public vetting of it. It's not surprising that it become intensely personal, but I would hope that political. But I would hope that maybe it does make us think about the way we're structuring the Supreme Court. That this is what these hearings have become. I think it for those who have put myself in this cap as somebody who has been a little reluctant to jump on either the court packing or cutting back on Supreme Court term bandwagon. I think I'm pretty solidly in terms of thinking we really need to cut back on the terms at some point, because the process is and the selection and everything about it seems to have become so deeply political that we might as well treat it as such, and that would mean imposing term limits. But those were my main thoughts.
Yeah, so I want to get Professor Funk in on some of this. Let me just offer just two quick observations. I worked in the Senate, and one of my for Senator Ted Kennedy, and one of my areas was judicial nominations. But interestingly, I didn't watch this hearing the way a law professor or an ex Senate staffer would watch it, from beginning to end. I consumed it much like the American public in little bits. And so I thought that alone was interesting, that a lot of this happened somewhat with the Gorsuch hearing, but I saw this even more now, the sort of sending of little clips through Twitter. And I wondered how that influenced how senators approach the process, if they thought of themselves as sending things that could be consumed in these little bites, even more, I think, than television bites, these sort of gotcha moments, kind of on social media steroids. So I thought that was interesting. I also couldn't remember a confirmation hearing that had so many protesters. And it may be that in history there has been, but just the disruption of the actual hearings and then the protests in front. So I think it's interesting to think about, one of the questions is really who's paying attention besides elites in all of this. That was always our question when we were working on confirmation. It would poll lower as the lowest salient issue of any issue that we did. Granted, we were mostly doing appellate court confirmations, but are more people paying attention? I think it raises that. But Professor Funk, I wanted to bring you in also, just maybe picking up on some of the things that Professor Metzger said about the confirmation process. Is it fundamentally broken? And what do we mean to get out of these hearings anyway?
Sure. So, anytime a seat comes open, usually commentary starts up on whether we should do something to actually change the confirmation process, to sort of de-Twitterify it, lower the political stakes, and especially to even out the happenstance of when seats come open, maybe to even it out so that each party gets sort of a set number of confirmations over time. Because this seat was Justice Kennedy's, the ostensible swing vote on the court, that rhetoric is maybe a little more heightened this time, and the proposals a little more aggressive, including a phrase already uttered that usually hasn't been spoken in years except in a whispered horror, but as a legal historian, it warms my heart to hear court packing come back into the common vocabulary. And so there have been some attempts at a serious proposal of how maybe court packing could be on the horizon in a way that's not just power politics, but is tied to some kind of procedural principle. Most prominently, this is coming from John Witt and Ian Ayres out of Yale, trying to tie it to a principle of well, the process over Garland was impermissible, and so there needs to be some sort of court packing remedy for the Democrats to engage in. Personally, I think that idea would have had more credibility if trotted out at the Gorsuch nomination. As we get into a second appointment of the Trump administration, it becomes harder to see where that kind of principle is going to end. Like, are we committed to there always has to be a swing seat on the Supreme Court, and it must now always be filled by Merrick Garland going forward, and world without end? But that's not to say court packing is not a viable option. As a legal historian, it's been done successfully a lot in the past. And it is one avenue that the Constitution leaves open to the Congress, though I think getting around the problem of it just being a power politics play is really the hindrance to it, because every time it's been successful in the past, it was more or less a power politics at play. I actually do think that is somewhat more viable of a path, though, than the other reform proposal that tends to be taken much more seriously, which is subjecting the justices to term limits. The most common figure passed around is 18-year term limits as sort of a way of making it a modest proposal. To me, I'm not sure that would actually solve any of the problems people currently have with the confirmation process. First of all, you can do a lot of transformative work in 18 years, so it's not clear how much of a limit that is. But also, it doesn't solve the problem of happenstance necessarily. There can still be health issues, the Grim Reaper intervening in your 18-year term, so that you still have the problem of surprise vacancies and appointments. And the other real problem is commentators disagree on whether the Constitution would have to be amended for term limits. To me, I think it very clearly would. So my advice would be, if you're going to dream the impossible dream of a constitutional amendment, you should probably dream a little bigger than just term limits for the justices.
Yeah, and so there's a lot more to say on this in terms of the process, because I think it raises questions about the role of courts in our society, ultimately of the Supreme Court, and also the relationship of the branches. I mean, just maybe the Senate should have more of a role here in terms of advice and consent. I mean, there are many ways to think about reform. Smaller issues is the abolition of the filibuster with regard to Supreme Court nominees, and is that the right way to go? So I actually want to bring in Mr. Jaffer, but because Professor Greene has to leave, I'm going to actually let you have 2 minutes. I've gotten Mr. Jaffer's permission on just the future of the court. Anything you want to say before you leave about substantively some of the direction you expect the court to go in around, I think you said you would talk about some civil rights issues and maybe reproductive freedom.
In 2 minutes. Well, let me take part of those 2 minutes just to say that it is just like the Democrats to try to denormalize court packing when there's a Republican president and a Republican Congress right now. They should maybe wait till they're in power before they just start talking about that. But so I'm going to say a little bit just about the kind of short-term future. We can only talk about the short-term future because things can change so quickly, even though it can often look like things are changing for generations. You never know what happens. So in terms of civil rights, in terms of reproductive freedom, so just on race issues, I think major issues that will continue to be before the court is, of course, race-based affirmative action. Justice Kennedy was the deciding vote in a number of cases implicating issues at the core or at the margins of affirmative action. The Fisher case out of the University of Texas, which essentially affirmed the viability of the University of Michigan 2003 standards, for race-based affirmative action. In that case, Texas uses a 10% plan that automatically admits the top 10% of students in Texas high schools to the University of Texas at Austin. And they filled out, that only fills out about 80% of the class, so they filled out the rest of the class using a model of race-based affirmative action that was modeled on the University of Michigan. Kennedy was the deciding vote upholding that in 2016. That was a 4-3 decision. Brett Kavanaugh has said a number of things around issues of race that suggest the strong possibility that he is much closer to the dissenters in that case, including in an interview in which he said that he looks forward to the day when the court concludes that we are all one race in the eyes of government. That kind of language it suggests an affinity with the so-called colorblind constitution. Of course, one doesn't know until one sees the actual decisions, but that would be a prediction about where Brett Kavanaugh sort of sits on these issues. Justice Kennedy was also the deciding vote in the parents involved case in 2007, which allowed, given Justice Kennedy's vote, allowed some race consciousness in making admissions decisions and around primary and secondary education. He was the deciding vote in a recent case that said that claims under the Fair Housing Act of racial discrimination did not necessarily have to prove intentional discrimination. So that was also a 5-4 case with Justice Kennedy in the majority. Justice Kennedy has also shown some sensitivity to some criminal justice issues that have a disparate impact on people of color, issues involving prison overcrowding, issues involving the death penalty, issues involving solitary confinement. And so, again, one doesn't know how Justice Kavanaugh is going to decide these issues, but there's at least circumstantial evidence that he's more likely to be with the dissenters in those cases. I'll say just a word about LGBT issues, just because that's an area where Justice Kennedy, that's probably the single most significant part of Justice Kennedy's legacy, writing the majority opinion in Romer versus Evans, in Lawrence versus Texas, in United States versus Windsor, in Obergefell versus Hodges. So really every really significant LGBT-related case the Supreme Court has decided, the majority opinions written by Justice Kennedy, in Masterpiece Cake Shop as well. And so here I think we have a little bit less evidence of where exactly someone like Brett Kavanaugh sits. He didn't comment on any of those cases substantively at his hearing, but he did quite conspicuously make reference to Justice Kennedy's statement in Obergefell, in which he said, not in Obergefell, in Masterpiece Cake Shop, in which he said, "Our society has come to the recognition that gay persons and gay couples cannot be treated as social outcasts or as inferior in dignity and worth." And he kept referring to that statement, I think, to try to signal some kind of wokeness with respect to this particular issue or set of issues. But again, we don't really know where he sits. I think the most salient issues involve the kind of denial of service claims that we see in a case like Masterpiece Cake Shop, employment discrimination, which remains a significant issue and may very well get to the court quite soon. The question of whether sex discrimination includes sexual orientation discrimination under federal anti-discrimination law, adoption and other family rights issues for same-sex couples, and issues of discrimination involving people who identify as transgender are also issues, I think, that may well come to the court in the next several years. And again, it wouldn't surprise me if Brett Kavanaugh is relatively tolerant in this area, but not especially creative or boundary pushing, if I had to make a prediction, but it's very hard to know. On reproductive freedom, and in the interest of time, I'll just say quickly about abortion rights. I think Kavanaugh sent a relatively clear signal that he's fairly hostile to Roe versus Wade and to Planned Parenthood versus Casey. He didn't say that explicitly, but he did say that he was asked about Griswold versus Connecticut, which is a birth control case from 1965. And all he was willing to say about that was he really liked Justice White's opinion, concurring in the judgment in that case. And Justice White is a Roe dissenter, conspicuously. He mentioned Washington versus Glucksberg as the defining case. He said all roads lead to Washington versus Glucksberg as the case that determines substantive due process rights and unenumerated rights. Glucksberg has never been applied in a majority opinion since it was decided, and yet he said that was the key case, and it was explicitly disavowed in Obergefell versus Hodges. So that's a pretty clear signal that he is with the dissenters in those cases. But again, I think it's hard to know exactly what happens with respect to a case like Roe. It doesn't necessarily mean that Kavanaugh is a vote to overturn Roe, although if I had to guess, I would say he would be if it were squarely presented to him. I think more likely you'll see a number of state laws restricting abortion rights that get to the court in various forms. And my expectation would be that the court is very likely, unless the composition changes, to uphold those state restrictions. So that's a 20-week ban. That's a ban on the most common method of terminating a pregnancy in the second trimester. That's even potentially laws that say that you can ban abortion once there's a fetal heartbeat, which is very early in the first trimester, are potentially laws that could be upheld by this court. And so I think any sober assessment of the current court plus Kavanaugh would have to believe that the future of abortion rights is fairly dim. And I'm going to be out now.
Okay, thank you. He's like, drop the mic. So, well, after you use Kavanaugh and woke in the same sentence, you're allowed to leave. So, Mr. Jaffer, can you talk about national security or free speech, privacy issues? Where do you expect the court to go on some of these issues?
Sure. Okay, so first, thanks for inviting me to participate in this. I guess it'd be hard to be grimmer than what we just heard. But on national security, I guess my expectation, not so much because of Kavanaugh in particular, but because of changes at the court over the last decade or even longer, is that we'll continue to see a lot of deference to the political branches on national security issues and to the executive branch in particular. Over the last 17 years, we have seen the appellate courts over and over again refuse to engage with the lawfulness of national security policies. And so cases involving interrogation and torture have been dismissed on immunity grounds. Cases involving national security surveillance are dismissed routinely on standing grounds or on state secrets grounds. The targeted killing cases are dismissed on political question grounds or on vivid special factors. You know, there's always a whole array of choices for a court that wants to dismiss these cases at the threshold. And the appellate courts have done that over and over again, and the Supreme Court has repeatedly denied cert in those cases. And in the very few cases in which the Supreme Court has granted cert, it's done so to overturn those appellate courts that were audacious enough to reach the merits. And I think that we're going to continue to see that, and everything we know about Judge Kavanaugh, I think is sort of consistent with that and suggests that we'll see a sort of further extension of that trend. So that's national security. I'll try to do each of these in 1 minute. On free speech, we have already seen the Supreme Court gravitate towards a libertarian conception of the First Amendment. I think the addition of Justice Kavanaugh is going to further that trend. There is a sense in which this Supreme Court is maybe more enthusiastic about the First Amendment than any Supreme Court before it. But it is important to recognize that this court is enthusiastic about a particular vision of the First Amendment, which privileges self-expression and autonomy and de-emphasizes self-government and truth-seeking, the other values of the First Amendment is sometimes thought to protect. And many of the most important cases that are likely to come before the Supreme Court, the most important First Amendment cases that are likely to come before the court over the next, say, decade, are cases in which you'll see free speech interests or First Amendment interests on both sides of the V. That's true of campaign finance cases, commercial speech cases, cases involving net neutrality, cases involving a regulation of the social media platforms. You have one party that invokes the First Amendment. The social media platforms, for example, will invoke the First Amendment as a defense against government regulation, and their users on the other side will invoke the First Amendment as a justification for the regulation. So you're guaranteed that the First Amendment is going to prevail in those cases, but it's one particular vision of the First Amendment that will prevail, and sometimes a triumph for the First Amendment won't necessarily entail a triumph for the values that some of us want the First Amendment to serve. So and I think, again, Judge Kavanaugh's addition to Judge Kavanaugh wrote an opinion just a couple of years ago making clear that he didn't think the FCC had the authority to regulate the broadband providers as common carriers. In other words, didn't have the authority to impose net neutrality rules. And I think that's a good indication of where he's likely to fall on these cases that pit speakers' interests against users or listeners' interests. If you are critical of the Supreme Court's recent jurisprudence on campaign finance and commercial speech, I don't think that Judge Kavanaugh's opinion on the net neutrality case is something that should make you optimistic about how he's going to come out on other cases of that kind. Then finally, informational privacy. Here, I actually don't have any idea what the future holds. The conservative wing of the Supreme Court signed on to Jones, which is the first location tracking case from 2012, signed on to Riley, which is a cell phone search case, signed on to Carpenter, which is the more recent location tracking case. Chief Justice Roberts wrote the Riley opinion. And Kennedy was in dissent in Carpenter. So the privacy coalition that exists on the Supreme Court may not need Justice Kavanaugh's vote. If it does need Justice Kavanaugh's vote, though, I think there's reason to doubt that it will get that vote. There's a case in, I think, 2012 called Clayman versus Obama, which involved the National Security Agency's cell phone call records tracking program. It involved the dragnet collection of call records. And Judge Kavanaugh wrote a concurrence in which he made clear that he thought that the dragnet collection of call records didn't constitute a search under the Fourth Amendment. And that part of his opinion, I think, would be difficult to defend now that the Supreme Court has decided Carpenter. But Judge Kavanaugh went on to say, even if it does constitute a search, it's justified by the special needs doctrine. So I think even after Carpenter, it looks like Justice Kavanaugh, is going to be very sympathetic to government programs, at least in the national security sphere, that implicate individual privacy. But that, again, I think the privacy issue, the informational privacy issue, is one that I think is relatively difficult to predict where it's going to go, just given the unusual alliances that we've seen on the court in those three cases I mentioned.
Thank you for that. I'm going to go to Professor Metzger. What do you see ahead when you think about administrative law issues or separation of powers, some of what we call structural issues in constitutional law?
Sure. Well, actually, so Jameel mentioned the kind of libertarian First Amendment, and that has been part of an overall sort of anti-regulatory bent of the Roberts Court that has shown up in ad law in terms most sort of publicly getting into debates over the future of Chevron deference, for example. There are really two camps currently on the court. I'd say there are those who are the extremists in terms of saying that Chevron is unconstitutional. That's Gorsuch, that's Thomas. And then there are those who are skeptical about Chevron deference and want to cabin it in, but aren't saying that it necessarily is straight up unconstitutional. I would put Roberts in that camp. I'd have put Kennedy in that camp. My guess is that Kavanaugh will be a little bit more with Roberts and maybe more of a switch with Kennedy in that sense, in that I don't think he's somebody who thinks that, he's a DC Circuit judge. He's been applying Chevron nonstop, either to say something doesn't qualify for Chevron or occasionally that it does. But I don't know that the constitutional attacks on that doctrine are going to appeal to him.
And
But-
can you just do 10 seconds
Oh,
just for
sorry.
the 1Ls?
Yes.
I just see some
Sorry,
of my 1L
sorry.
students.
So,
being like,
okay.
Chevron, are we
Sorry.
going to learn this?
So in administrative law, which you should all take, the real issues are often about to what extent courts review actions of administrative agencies, and do they sort of do a very thorough scrutiny of everything an agency decided, or do they defer to agencies on certain questions, sometimes statutory interpretation questions. And so the doctrine that says you should defer in some instances to agency statutory interpretations is a doctrine called Chevron. And it's been very much under fire recently at the Supreme Court. And it's part of an overarching feeling from the Roberts Court of skepticism about administrative government writ large. Some of that skepticism has taken a real constitutional flavor. So there've been a lot of separation of power cases, striking down certain kinds of regulatory arrangements on separation of powers grounds. And sometimes it's taken an attack on these administrative law doctrines. I think that I think that Kavanaugh will be skeptical in general. He'll be on the skeptical side of administrative action. I don't think he's going to be as extreme as some, but I think he's going to be one of the ones who will find reasons not to defer and to look at agency action more searchingly. The case that Jameel mentioned, the net neutrality cases, his opinion in that case is actually quite interesting from an administrative law perspective, because he said basically when it's a sort of major rule, like a major expansion of federal regulatory authority, Congress needs to authorize that expressly. And that goes to the question of deference to the agency's action, but it actually also goes to whether or not the agency has any authority to act. What we would put constitutionally more under a category of delegation. Was the agency delegated authority? And there's a case already on the docket for this coming term on delegation, and many of the issues about deference are really questions about the ability to delegate to administrative agencies anyway. So I think Kavanaugh is actually going to be a pretty conservative vote on delegation, and overall a skeptical view of administrative action. Now, you should pause and think, how will that play out when you have a Republican administration? Right now, the lower courts are in many ways being very skeptical about the actions of the Trump administration under administrative law. And many hot button questions like the DACA and the deferred action for childhood arrivals have been the efforts by the Trump administration to repeal that have been stopped by the courts on sort of searching scrutiny in terms of whether or not they're arbitrary or not, or whether or not the administration has complied with the requirements for rulemaking, procedural requirements. So it'll be interesting to see whether or not the Roberts courts remains as searching as it has been under the Obama administration of some of these administrative law decisions. On straight up separation of powers questions, I just want to say, I mean, the big one here is presidential power. I think Kavanaugh has a very strong view of presidential power. I think if you look at the article he wrote in Minnesota, it's pretty extreme in terms of presidential immunity, suggesting even immunity from investigation. In the hearings, he was talking about Nixon as if he agreed with Nixon, but if you don't have the power to investigate a president, I don't think the Nixon case really arises, because the grand jury is operating as part of an investigation. So I think he's actually fairly extreme on that. There have been some interesting decisions on separation of powers challenges to administrative regimes, where he has taken a position that has struck those new regimes down in a way that the Robert courts has adopted. So I expect him to be very much on the piece with the Roberts court on those. I think the real question, and something he wasn't really pushed on, I thought, unfortunately, in the hearings, is how far he will go in sustaining congressional limits, for example, on the president's ability to remove agency heads. There's a very long-standing decision called Humphrey's Executor, which Kavanaugh invoked and said, well, Humphrey's Executor says this much, and these other regimes went beyond it, and I thought those were unconstitutional. But the real question is whether or not he's going to stick with Humphrey's Executor, and I don't think he was really pushed on that in the hearing.
Thank you. So I'm going to turn it, just before we open it up for questions, to Professor Funk, who's going to talk about voting and presumably voting ID or partisan gerrymandering, which are cases that we expect to be before the court.
Sure. So I'll pick up quickly where Mr. Jeffers left off on campaign finance. Judge Kavanaugh has expressed his personal view in the past that he's pretty much a First Amendment purist, to the extent that he believes personally that even personal contribution limits run afoul of the First Amendment. Whether or not that means the Supreme Court will ever actually take up those limits anytime soon, it does mean that probably Citizens United is here to stay for a while. There's not going to be any rollback on the unlimited corporation right to contribute financially to campaigns. On actual voting rights itself, to be brief, it's probably going to be business as usual, as the cases have been coming out in the court. Justice Kennedy was not in many 5-4 majorities that are suddenly going to be gone or in peril. It's hard to say something concrete across the board on voting rights, because each decision kind of comes out in a different and unexpected way. The last time we had a 5-4 voting rights case, it was Justice Thomas joining the 4 liberals. So you never quite know what's going on here. What we can say is the Voting Rights Act is sort of under strain from all sorts of angles and dimensions, and even the liberal side of the court sometimes can create problems in the Voting Rights Act. You know, trying to establish robust claims under Section 5, which has to do with taking race explicitly into account as you're drawing lines. Sometimes in upholding claims under Section 5, liberal justices such as Justice Kagan or Justice Kennedy would then put strain on claims that could be brought under Section 2, which has to do with vote denials and vote dilutions. This becomes important as litigations challenging voter ID laws, different kinds of what plaintiffs are challenging as voter suppression laws come before the court. We actually have a decision from Judge Kavanaugh, who sat on a trial court. Voting rights is handled a little differently, where initial challenges go before 3-judge panels at the trial level. Judge Kavanaugh was on one of those panels in 2012, a challenge to South Carolina's voter ID law, which he upheld sort of narrowly on the promise of local officials that they weren't going to enforce the law as written, but sort of add extra protections in the actual implementation of the law. These kinds of decisions are always so factually detailed that it's hard to know what the trend will be from them. But what we can sort of generally say is that, you know, the division in the court is not so much over one particular doctrine or area of the Voting Rights Act. It's really, you know, one side tends to see systemic racism as a problem that the courts really need to be inquiring into in the challenges that come before them. And the other side that says legislatures should have a lot of leeway to sort of rationally address threats to the integrity of the voting system. And the rationality of those threats are only sort of the rationality of addressing those threats are only actually going to increase now that we have, you know, more and more evidence of Russian interference and attempted tampering with elections, that you could actually see a much stronger push for voter ID laws and anti-tampering laws, which can also have suppressive effects. What we can say is Judge Kavanaugh, I think, is much more in the latter camp of deferring to legislature discretion than he is in the former camp.
Thank you. Thank you for that. Okay, so we're going to open it up to questions.
Hi, Professor. Thank you for giving us the talk on Judge Kavanaugh and his possible views on a lot of issues. I specifically have a question that was reminded by the discussion of the FCC's net neutrality and the possible lawsuits ensuing after New York and California intended to pass strict net neutrality bills. So my question to Professor Metzger is that, do you think there will be a development in terms of preemption rights of the FCC on state legislations, and how do you put that in perspective on a larger issue of state versus federal rights administrative issues?
Yeah, it's a very interesting question. So I would begin by saying, in general, the Roberts Court has been fairly pro-preemption. In particular, Roberts and Alito, I haven't seen recent couple of years data, but they had extraordinarily strong preemption votes. I would expect that the court would continue to be pretty pro-preemption. I don't know the details of the cases, so it's without knowing the specifics of the state laws and how strong the preemption arguments are. I mean, you could say a federal law does not require it as a matter of federal law, but that still leaves plenty of room for a state to. Or you could say that this is an issue that, because of the Telecom Act, is among the Telecom Act issues really given over to the federal government and the FCC to regulate, and that it really kind of in that sense occupies the field, and this is an effort by states to move into that area. You might, Jameel, be better able to talk about the specific merits of it, but overall, the Roberts Court has been pretty pro-preemption, and I would expect Kavanaugh to probably be in that similar camp. Your point is interesting, though, because one of the effects of being on the DC circuit is I don't think we have an overarching sense of how he is really on federalism issues. The one federalism issue that comes immediately to mind had to do with the constitutionality of the Affordable Care Act. And that was one where he sort of wanted to rule on jurisdictional grounds and not to engage on the merits of it. There may very well be others, and I'd open up to if other people can think about federalism things, but I don't feel like I have a very strong view. But somebody who's been raised in the world of federal agency regulation might actually be more willing to consider preemption acceptable in those areas than somebody who's been focused more on the state.
Did you want to add anything about? Okay. Yes. Yes.
Question, but given the politicization of the courts, that Kavanaugh is, going into a swing vote, and all the protesting around, what Kavanaugh may decide. Do you think that Kavanaugh and the rest of the court are cognizant of how their decisions on politically salient questions will affect the legitimacy of the court? And do you think that that is a factor in their decision making of, whether they take certain cases or whether they decide in a particular way?
Yeah, and I invite anyone who wants to comment on that extremely challenging question. I mean, there's a kind of strain in when people think about courts and think about the Supreme Court, where they say they never stray too far from public opinion. People have talked about this sort of historically and empirically, that they're really pushed a lot by public opinion, and that sometimes justices change over time and sort of move more into the center. So I just would add that piece to the question, because there is that theory out there. How do we see this playing out?
One of the surprising things that Judge Kavanaugh says is that his hero on the Supreme Court, he obviously admires Justice Kennedy, whom he clerked for, but his hero is William Rehnquist, who was never very worried about whether he was a swing vote or not, or a lone dissenter. So I'm not sure how much a Judge Kavanaugh will think of himself as a swing vote. On the other hand, there are several opinions by Justice Roberts that I think don't make much sense, except that he is thinking hard about the legitimacy of the Supreme Court, and sometimes possibly switching sides to make sure it doesn't fall into too much of a political maelstrom.
The only thing I'd add to that is that it may actually be something hard that is not so visible, because it may very well turn on what kind of, as your question suggested, which court cases they grant cert on, and it will be hard to know whether or not Kavanaugh decided not to grant cert on some potentially contentious cases, or if the court doesn't grant cert on them.
Okay, we have time for one more question.
My question is about separation of power and where Judge Kavanaugh would end up. It seems do you think there's a consistency in his belief of, maximum power to the executive or immunity, or would that change, you think, depending on who's on the White House?
Oh, and I
Yeah.
should have reminded everyone, the questions have been great. This is all being Facebook Live. Is that a word? I say it every year, but it's on Facebook.
Now she tells me.
Didn't they tell you before?
Yeah, probably.
Okay.
Don't worry. I think it's a general writing assumption.
I just thought this
Yeah.
question maybe was
Yeah.
one where you might be reminded.
Yeah, it might need a little reminder. I think the interesting thing about Kavanaugh is there has been evolution in his views on separation of powers. I mean, and also I think he does, even if I don't necessarily agree with his views, deserves some kudos for being public about that. He was part of the Starr investigation, and then he wrote an article sort of critical about some of those moves. So I think that does. Those were based on experiences that he had, but I think it does show that his views have changed to some potential degree. I've been struck when I look at the separation of powers reasoning again that, I would put him in the camp of, I think he described himself more as an originalist, certainly as a textualist, as I would think he'd be more as that thinking tends to go of a more formal constitutionalist when it comes to constitutional structure. And if you look at his most recent dissent, which is the one where he said it was unconstitutional, the structure of the Consumer Financial Protection Bureau was unconstitutional because it was this one single director that had all this power. The thing that really strikes me is that the reasoning there is very functionalist. It's very much concerned sort of about the lack of checks and balances. It's not sort of this kind of formalist unitary executive in its thrust. And I'm not really sure whether that shows some degree of evolution, that he's come to accept certain baselines and is now reasoning within them, whether that was just the way the case was teed up, and he sort of had a result that he thought was the right one and was willing to use whatever argumentative tools get you there. My own guess is that there are the questions that come up tend to about administrative law or separation of powers tend to be different based on the administration. So if you've got more of a democratic progressive administration, you're going to have more of a pro-regulatory measure that is then being challenged by anti-regulatory folks. And so if you are somebody who is a little bit more skeptical of administrative action, you might be more searching in that context. But it's not necessarily because it's a democratic administration, it's because you have certain skepticism about certain forms of regulation. You might have more of a libertarian bent and be more skeptical of it. So I'm not, in that sense, I would very much be cautious about saying it has to do with who's in the White House, but the nature of the claims that come up can differ in ways that may trigger a different response on the court.
Well, this has been wonderful in illuminating both the process and I think some of the substantive issues ahead. And as Dean Lester said, it was in fact thrilling. So I just want everyone to join me in thanking our panelists, and thank you all for coming.